Hello, and welcome to Mean Street News. Mean Street News is here to provide accurate news to help citizens affect change in their local government and beyond. Being nice is overrated. It is time to be real. I mean what I say, and I say what I mean. The time to step up and step in is now. So please come join me, Katie, over on Mean Street News to discuss Ohio politics and beyond. I hope to see you there. Hello, and welcome to Mean Street. Hello, and welcome back to Mean Street News. I am Katie. Thank you for joining me tonight, and I'm going to get right into it. Tonight, we are going to be talking about our new prosecutor, Tony Cillo, filing a motion to vacate the sentence agreement and the everything preceding a sentence agreement in the Lorain County Head Start case. Now, if you're unfamiliar, the Lorain County Head Start case was in 1993. Nancy Smith and Joseph Allen were convicted of crimes against children. Later found out that they were innocent. In 2000, I believe 9, Judge Burge acquitted their sentence. It went back to the Ohio Supreme Court, where it was found just on a technicality that it wasn't appropriate. So Judge Burge did not resentence them. Sorry, I have a piece of hair. Judge Burge did not resentence them during that time. What he did is he kind of left it alone. When the next that prosecutor, Dennis Wills, and Assistant Prosecutor Tony Cillo then approached Nancy Smith with a sentence agreement for 12 years and Joseph Allen with a sentence agreement that put him back in prison. Nancy stayed out of prison. Joseph Allen went back, and that's brought up during the amended sentence. Now, instead of going through the entire story and where it was wrong and take up all that time, what I did is I made a video for you all to watch. It's about 15-20 minutes that goes over all the issues in the case, starting with the mother that reported the first allegation, how the media contributed to the hysteria regarding the facts, how more kids came out after the mom recruited people, how Nancy Smith's attorney didn't allow certain testimony that probably would have exonerated her. And then after you guys watch this video, I'm going to get into Tony Cillo's motion that he, I don't know, it's a filing that he did regarding to vacate the sentence agreement that J.D. Tomlinson then later in 2022 ended up dismissing all of the charges against Nancy Smith and Joseph Allen. And Tony, our new prosecutor, Tony Cillo, now wants to vacate all of those motions. And I don't know what that would end up for, what the outcome of that would be if that were to happen for Nancy Smith. But I'm also we're gonna go through his arguments, and I'm gonna show you clearly why his arguments aren't valid. But first, I want you to know the Nancy Smith case a little bit. So I want you to watch this video. Give me 5 seconds. I'm going to share my screen. Entire screen. One second, you guys. Got it. Let me open this video. Full backstory. Here we go.
And expose them to a pedophile.
All right. It's out of here. Give me 2 seconds, you guys. And you guys are going to watch this video first, and then I will be right back.
and expose them to a pedophile named Joseph.
Take off our clothes and then Joseph plays with us.
The play, which the little girl said took place in a messy basement, went way beyond dolls. She described explicit sexual acts.
So then, she said he stuck a predator inside of her.
Upon hearing that her little girl may have been violated with a stick, the mother took her to the emergency room for a full examination. That's when the police were called.
The officers took the report at the hospital, and the detectives do a follow-up on the investigation.
When Detective Tom Cantu got the case, he immediately went to see the girl and her mother to ask what else they knew about this Joseph.
She was saying that he got on a bus several times, and he was described as either a black male with white spots or a male with discolored skin areas on his face.
The girl also told her mom that this spotted black man had blue eyes and that he would sometimes urinate on her and other children after Nancy served them milk and cookies. The detective brought Nancy Smith in for questioning.
Okay, Nancy. You have the right to remain silent?
I told her what the complaint was and the possible charges. Of course, she broke down. She said, I did nothing like that. I love the kids.
Do you have a bus that you have a bus with you?
Yes, I do. All the time. We are not allowed to run our buses without an aid. We are not allowed to pull away without one. That Friday, Sherry Hagerman was on my bus.
The detective noted the name of Sherry Hagerman, the bus aide, in his report, but didn't ask any more about her. Instead, he was more interested in finding Joseph.
If they're talking about a guy in there named Joseph, who's Joseph?
I have no idea. There's nobody that works with me named Joseph.
I asked Nancy Smith, would you like to take a polygraph? Not a problem. She volunteered to take a polygraph.
But before that polygraph could be done, Detective Cantu was summoned to the mayor's office. Margie Grondin was there.
This woman screaming for justice, going to the mayor screaming for justice, the mayor screaming for someone to be arrested when the case was just barely begun.
Tempers were so hot that Cantu says he had to call in his supervisor, the chief of investigations, Sel Rivera, to back him up.
When I went upstairs, they were screaming at each other, a lot of profanity. So when I walked in, I told everybody to calm down.
Then the mayor kind of cooled his heels and let us do our investigation. But on the other hand, the mother kept on shooting off her mouth.
Then the accusing mom really turned up the heat. She took the case public.
One of their bus drivers drove them to a house where...
And now this stuff was publicized on TV and in the papers.
Margie Grondin, she organized like a meeting, of the parents involved.
All of a sudden, more children are coming forward saying they were molested by the same person.
Overnight, it was as if a sickening fear had blown in off Lake Erie. The parents of children of Nancy Smith's bus were panicked and calling the police with claims of their own.
It really mushroomed. It just mushroomed into a circus atmosphere.
Number one. And number two.
Released to a newspaper in 1997, the tape shows that Margie Grondin's daughter hesitated when asked to identify the man who abused her.
Look at each one, look at their faces, okay, one at a time.
For 8 long minutes, the girl stares at the men before her, reluctant to point out anyone.
Three step forward.
Until finally, her mother, Margie Grondin, literally takes matters into her own hands.
Yeah, number 2.
You want number two to step forward?
Mm-hmm.
The jury never saw that because the prosecution didn't show it, and the
discovery, and that may have just been overlooked.
But that was not the only revelation on that tape. This boy's mother, Emily Oliver, claimed she saw Joseph Allen near Nancy Smith's bus. At the lineup, she claimed Joseph Allen had grabbed her son, William, by the arm.
You recognize his voice from stuff?
Yeah, I did.
But on the day of the lineup, William did not pick him out.
Hey, William, look at each one.
At trial, Emily Oliver testified that William was so afraid of Joseph Allen that he left the room in tears.
You can take your shirt off.
But the lineup tape shows that was clearly not the case. Had the jury seen this, Emily Oliver's credibility may well have been called into question.
I don't remember anything happening to me.
William Oliver is all grown up now, and currently doing time in an Idaho prison for murder.
Nope.
You never saw Joseph and Nancy together?
The only time I saw them even close was on a piece of paper with their pictures on it.
So in your world, this is fiction.
Yeah.
Williams says Emily Oliver had a lifelong struggle with prescription drug addiction. She died 2 years ago.
I think in retrospect, it was Emily trying to cheat the system to maybe even to the extent of collect money for herself so she can support her habit.
And it turned out another mother who testified at trial also had a history with drugs, Margie Grondin herself. Court records show a few years before she accused Nancy Smith, Grondin had pleaded guilty to dealing cocaine out of her apartment. That was something Jack Bradley should have known about, since he briefly represented Margie's boyfriend and co-defendant in that case.
I never completed that case. A substitute attorney took over that case.
And you don't remember her
No.
turning?
Soto wanted the jury to hear about the night he says Margie Grondin told him a secret.
Margie did come to my house, knock on my door. She did told me that in the beginning of the investigation that the little girl was saying no, that didn't happen. I said, Margie, if this is serious, she's changing her story. You need to speak up.
The prosecutor, however, objected, and the judge threw that testimony out.
He said, no, this is hearsay stuff. We don't want to hear this. As a matter of fact, I think I got kicked out of that bench so fast that it wasn't right.
So much Monday morning quarterbacking, regret, and recrimination. And yet, as it turned out, perhaps the most potent piece of evidence available to the defense lawyers had been literally hiding in plain sight all along.
Statements until the second day of trial, when the prosecutor realized that they contained all type of exculpatory information. I asked the judge to play the tapes to the jury because they would certainly realize once they heard those tapes that these children had been manipulated. That was denied.
Detective Tom Cantu, the first investigator on the case, says he suspected from day one that the children may have been manipulated.
When I went to the house to interview the victim, the child victim, the mother wouldn't let the child answer any question. The mother kept on answering for the child. Then when I would ask the child, is that right? The girl, I don't remember. I don't know.
Cantu says his doubts about the case only grew when he couldn't find any physical evidence to corroborate that child's story. None of the houses the kids pointed out as being the places where and though the kids claimed they were all abused together, Head Start records show they were never absent or late for school on the same days.
Nothing matched, nothing. Nancy Smith drove a bright yellow school bus, just like the ones you see out here. No one's seen a school bus parked anywhere in any of the neighborhoods in the city. That'd be like a sore thumb. You put a school bus in the middle of any neighborhood, people would have seen it.
In 20 years as a cop, Cantu says he'd never seen anything like it. He says he recommended the case be dropped and thought it had been. But because of a promotion which took him off the case, he says he didn't know that new detectives had been assigned. Cantu says those detectives never spoke to him about his findings, and he was never asked to testify at trial.
Angers me to this day that I was never called to testify being the initial investigator. I think I could have influenced the jury.
Did you call Jack Bradley and say, put me on the stand?
I just figured if they thought my investigation was that important, they would have called me.
I remember no officers coming to my house or coming to me and asking me what happened.
Hagerman is the bus aide who worked with Nancy on the day Margie Grondin first told police that Nancy had helped Joseph molest her daughter.
They lied about everything. She never done anything to any child. We never took these kids anywhere. They were on the bus and they took them to their homes or to the school.
Hagerman says what's jaw-dropping is that Nancy's attorney knew her story, but never called her to testify.
I was supposed to go testify on her behalf, and I never did. Why, I don't know.
Hagerman isn't the only bus aide who wanted to testify on Nancy's behalf. Sue Coates had also been her aide during the months that the kids claimed the abuse was taking place.
I begged Bradley every day, put me on the stand, please. I was her aide. I know how she behaved.
The Head Start case was assigned to Jonathan Rosenbaum, an assistant prosecutor with a reputation for being tough.
John Rosenbaum He was a good man to have on your side when you're prosecuting the case because he was like a pit bull, very aggressive.
Rosenbaum declined Dateline's request for an interview, but in emails, Rosenbaum says the case against Nancy Smith and Joseph Allen was strong, highlighted by the testimony of 5 children and their parents.
So the prosecutor would tell the jurors, just go back to the children. Listen to what the children say. That is where you determine this case.
Not commit this crime. I don't even know that man. I have never, ever seen that man before.
A short time later, Nancy Smith was sentenced to 30 to 90 years in prison.
45372. I've never seen this man.
Her co-defendant, Joseph Allen, got 5 consecutive life sentences.
They took me straight to the county jail. Your kids are standing there. And I didn't know when I was ever going to see them again.
Was not sure how much longer she could hang on.
I had went to visit her, and it was actually one of the hardest ones, almost like she couldn't take it anymore, you know?
It was during that prison visit in 2007 that Nancy Smith and her daughter Amber hatched an audacious plan to get her out.
Well, I know I wasn't going to give up, but I didn't know where it was going to take me. I asked her if it happened, and she basically says she doesn't remember it.
She say anything more convincing than I don't remember or I don't know?
She just said that she could give me her cell phone number and maybe talk outside of her job. Unfortunately, the next day when I called, her mother answered and kind of hung up the phone.
There may have been a reason for that. After the criminal trial, Margie Grondin and the parents of 3 other Head Start children won multi-million-dollar judgments against Head Start's operator. The case was later settled for an undisclosed amount. The parents involved have not responded to Dateline's request for an interview and are apparently bound by confidentiality provisions. One of their lawyers told us, "All that I or my clients can say to you about the case is that the case is settled."
Do you think that was the driving force behind this whole saga?
I think so.
Money.
Mm-hmm. I think that's why now nobody will tell the truth, because they were awarded the money.
With the odds of a dramatic confession
and its clemency. So I made the phone calls for her. I downloaded the forms for her, and I gave her those forms. I said, this is what you have to do.
For months, they met, mostly on Saturday mornings, to strategize. The chief and the daughter of a woman he'd helped put in jail. Then one day, Amber says the chief stopped returning phone calls.
There was about 3 months where I hadn't heard anything from him, and I had told one of our attorneys, Mark Gotze, the things that he was saying. Well, Mark Gotze calls to talk to him, and he basically denies everything that I had told Mark. Like, he had never said any of it. And out of the blue, I get another email from him to come and meet with him.
Amber says this time she wanted proof that the chief believed in her mother's innocence. So she brought along that tiny tape recorder the chief had taught her to use.
Some of the things those kids said were so.
And are you nervous?
I think I was the first couple times, but even when he was denying to my attorneys that he never said any of that, I still had trust in him.
It just wasn't a good case. We weren't even sure they were going to prosecute it at first, you know.
Chief Rivera told Dateline that his department was not pressured to make an arrest. But to the lawyers working to get Nancy a new trial, Amber's secret recordings seem like a smoking gun.
And I think Amber's tapes are significant. I mean, this is the chief of police now admitting, essentially, that we knew this was not reliable and this was not a good case. Her testimony, what will eventually be, will show that they acted in bad faith and with political motivation.
And the political motivation being?
The parents were going and raising hell to the media.
It was only a matter of time before word of the Rivera recordings put the case back in the news, and Lorraine's chief of police in an awkward spot with the county.
I'm very, upset when I found out that she had taped me because I genuinely was trying to help her. I have not had contact with her since then.
In the end, however, none of it mattered. In 2009, the case took a dramatic and unexpected turn when a new actor suddenly took center stage. And this time it was someone who would actually do something.
It wasn't that I had a hunch they were innocent. I knew it.
Few trial transcripts, as well as medical records and pretrial interviews that were never presented in court.
If a child age 4 tells me that she's been vaginally assaulted with a stick, And for there to be no evidence of it would indicate that the story, of course, is impossible. As I got into the pretrial interview tapes, it occurred to me that there were no victims other than the children that had been led to believe that they had been abused.
At the end of that process, the judge says he arrived at one inescapable conclusion.
It wasn't that I had a hunch they were innocent. I knew it. And once I reviewed the file and I knew it, I was going to acquit them. It's just that simple.
So Nancy Smith had yet another day.
Pursuant to Criminal Rule 29C, corpus sua sponte, the jury having been discharged, enter a judgment of acquittal on behalf of the defendants Smith and the defendant Allen. In this matter, as it ends, the defendants are each discharged and their bond will be ordered released.
On behalf of the state, we object to the ruling of the court.
Thank you, Attorney Corey. The state of Ohio objections have been we're in recess.
I told you it'll be all right.
I just didn't know at that point. I had been so disappointed by so much that, I always had hope that somebody would be able to help me or do something, but I just never realized that it would be my daughter.
You're out now. You could go back to jail. There are people, a number of people who still believe you are guilty. To you, was there, you could have gotten parole earlier had you said that you were guilty, had you made a confession to a parole board. You never wanted to do that, though.
No, I'm not guilty. I'm an innocent woman. And I'm not going to sit and tell somebody that I'm guilty to go home.
What is it like to be convicted of something and to not have people believe you?
It's horrible. It's horrible, especially when you know that you didn't do anything. And you have these people out there making their judgment. But I've had more positives since I've been home. And I just don't feel like there's like a whole lot of people that are against me, especially when they, when things start coming out and things start coming to light. You can see the wrong that was made toward me.
Was released because there was a flaw in how she was sentenced. Now the Ohio Supreme Court says the judge did not have the authority to grant that acquittal. This morning, Nancy Smith faced a judge in Elyria. News Channel 5's Paul Kiska is live in Elyria right now. Paul, bring us up to speed on how it goes.
All right, Leon, on a cold, frigid day here in Elyria, this is a hot topic in Lorain County and throughout the region today. Nancy Smith, Joseph Allen are going home instead of going back to prison. They leave court free, still free, and they can go home. Nancy Smith, that bus driver, had a lot of family and friends in the courtroom today here in Lorain County. The two were convicted, as you said, in 1994 of molesting 4- and 5-year-old children. Smith drove the kids on her Head Start bus, took them to Allen's Lorain home, and the children were molested. Both convicts were in prison until 2009, when a legal error put them back in the courtroom of Lorain County Judge James Burge, who decided they were wrongly convicted and set them free. A state court said the judge, he did not have the authority to free them, exceeded his rule, and ordered the judge to hold another hearing to send them back to prison today. But the judge didn't do that. Judge Burge said, stay free. Nancy Smith broke down after court.
It's horrible. It's the worst feeling that you could ever have. To think that people would think that of you. Until you've been in my shoes, nobody can understand the pain that this has caused me and my family.
All right, again, Nancy Smith still free today. The bus driver breaking down after court, emotionally saying it's as she said, it's terrible to be wrongly accused. Joseph Allen was not in court. His attorney was. Now, the state Supreme Court is going to review this case, so it's not over yet. But again, for now, Smith and Allen.
Appears to have your signature on it, and it says Nancy Smith. You signed this agreement. And before you signed this agreement, did you go over this agreement? Did you read it yourself? Yes, I did. And did your lawyer also go over it? Yes, she did. And did she answer any questions you might have had? Did she explain to you? Did she do anything that you needed her to do so that you fully understood? And were you satisfied with the completion of that? Did you fully understood this agreement? The court has reviewed the sentencing agreement. And the court may inquire about counsel and of the defendant. The court is satisfied that counsel and the defendant have made this agreement. The court is in particular satisfied that the defendant has knowingly, voluntarily.
Back in your jurisdiction to determine how you wish to proceed on behalf of the state of Ohio and the citizens of Lorraine County, Prosecutor Thomas. What would you like to do?
Thank you, Your Honor. I would like to take this opportunity to thank the court for its guidance as I have attempted to navigate my way through these matters. I'd also like to thank and recognize defense counsel, Mark Gotze and Sharon Katz on behalf of Ms. Smith, and Ricky Parsons and Paula Brown on behalf of Mr. Allen for their tireless work over many years advocating for their innocent clients. And to Ms. Smith and to Mr. Allen, I want to say that I apologize to you, especially for what was done to you and to your families as a result of this ill-conceived prosecution. On behalf of the state of Ohio, I wish nothing but the best for you and your loved ones. And I hope that in the future, only happiness and good fortune may follow you. Your Honor, I will be moving this honorable court to dismiss these matters. I am in possession of proposed judgment entries that have been signed by counsel.
Would you give it to Ms. Pena or Ms. Bring it up for me? I'll take a look at it.
Why am I not appearing? Here we go. So going through that video, it's a little confusing on what happened with Nancy Smith when you start going over all the times she was in court. So I'm just going to run it over with you real quick. And Joseph Allen. So on November 10th, 1993, they were indicted for the child molestation charges. They were found guilty. I believe it was July of 94. They appealed for 10 years. All of their appeals were denied. In 2008, Judge Burge, the judge of Lorraine County Common Pleas, reconsidered sentence. He said the entry did not, sorry, I'm reading right now. The entry did not comply with the criminal rule 32C, which is not final appealable order. Okay. Burge issued an order of Smith, and then later Burge would issue an order of Smith's acquittal and Joseph Adams' acquittal, which means get rid of the charge. They're free. In 2009, the Attorney General and Dennis Will, Lorraine County prosecutor, petitioned the 9th District Court of Appeals ordering Burge to vacate his orders of acquittal. The 9th District Court dismissed those petition, and then they appealed to the Supreme Court. And the Supreme Court reversed the 9th District's dismissal, ordered Burge to vacate his acquittal, which Burge never did. Which is, he said, remain free, which is why then in that video they said remain free. In 2013, Burge accused himself, and then it went to Nancy Woods when Nancy got the settlement agreement. June of 2013. She was sentenced for 12 years and then waived her rights to raise state or federal challenges to her conviction or appeal conviction sentences agreed to not bring up any and all actions. So then we have JD Tomlinson. So she has a sentence agreement. So then in 2019, JD Tomlinson runs against Dennis Wills and he wins. And part of his campaigning was this Nancy Smith case. He felt that she was wrongfully convicted. And she did work on JD Tomlinson's case, JD Tomlinson's campaign. And a year after getting into office, her attorneys contacted the prosecutor's office and wanted to, and put in for, I think it's like a amendment to the settlement and then a resentencing hearing, I believe it was. Don't quote me on that. But at that resentencing hearing, where you see at the end of the video, JD Tomlinson dismisses the sentence agreement was amended by the judge, and then he moved for a motion for a new trial. At that new trial, the prosecutor dismissed all of Nancy Smith's charges. Now, that is exactly what the new prosecutor, Tony Cillo, is, and it's been Joseph Allen charges. That's why the new prosecutor now, Cillo, wants the court to vacate both the judgments, and both judgments are the sentence, the settlement agreement amendment, and dismissing charges. Okay, which is the motion for the new trial. Now, his argument on his filing is that it generated these dismissals were generated as a result of wide-ranging fraud. Okay. That's his argument. Now, I am going to show you, because I don't want to tell you guys what to believe. I want to show you. So we're going to look at, in the Court of Common Pleas, General Division, Lorraine County, Ohio. The judge is Janet Burnside. And I'm going to share this screen with you so you can see. Okay. Leave me here. No, I don't want to be there. I can be there. Right. Here is Tony Cillo's filing. Okay, so he's saying, Honorable Court moves to this court to vacate the following judgments previously entered. The judgment accepting an amendment to the sentence agreement that had previously been filed with this court on June 4th, 2015, and by the court on December 29th, 2021. The judgment granting Nancy Smith leave to file a motion for a new trial in this matter, as well as deeming her motion for a new trial to be filed, entered by this court on December 29th, 2021. The judgment granting Smith's motion for a new trial, entered by this court on February 25th, 2022. The judgment accepting the documents submitted by the parties declaring the June 4, 2013 sentence agreement to be void ab initio entered, which means voided, like not, it doesn't exist anymore, entered this court by February 25th. Now, what I find funny here is he wants the judgment granting. Okay, never mind. Okay, Nancy, because that's the one that got Joseph. That's my question, is the Joseph. Now I just realized that. Is where's Joseph Allen in this? Because there was two plaintiffs. Maybe they just gave me the Nancy Smith one. But if there's not one for Allen, Joseph Allen too, that's really interesting. So Tony filed this on November 10th of 2025. Okay. Now what are his arguments for this? The interference, for one, in the post-conviction proceeding resulted in 4 separate affirmations and convictions over a span of time exceeding 8 years. I don't really believe that because she maintained her innocence, deplorable true. But the interference of James Burge is why he's saying is first an issue on why he wants to vacate both judgments. He's saying, you know, James Burge was a judge on this case, and because he was a judge on this case, it's inappropriate for him to have anything to do with Smith's case. Recuse himself. Here we go. I'm trying to find. That's why I'm lacking. Give me a second. I gotta find it. I think it's page 30. Let me start on here. This is just I'm going after the background. They're saying that Nancy Smith, this was his exhibit saying Nancy Smith worked on JD's campaign. And here's my the quid pro quo and the conspiracy. So there has to be, in order for it to be a conspiracy, there has to be something to get out of it. He's trying to say in 2019, JD ran against Dennis Wills. He gained an eager supporter in Nancy Smith. And you can see that through posts. And Smith expressed avid support for Tomlinson as bid to unseat Will. Of course she did. Dennis Will helped her put her in prison, helped with the sentencing agreement. I wouldn't want to be done, you know, I need Dennis Will. But he's kind of insinuating, he says may have worked on Tomlinson's. She did not work on Tomlinson's campaign leadership team. She was just a part of, you know, supporting him. So this is his quid pro quo. Tomlinson benefited from Smith's efforts and won both the primary and general elections for the prosecuting attorney. Nancy, and this is why it's so ridiculous, Nancy Smith alone did not win JD Tomlinson. She not convinced 10,000 people who voted for JD over the other one to win his election. That's not a quid pro quo. So that's the first, I believe, fallacy in his like argument. The first, you know, it's not a thing. It's just not a thing. Her helping him on his election didn't win him the election. Him hitting all the doors he did, him campaigning the way he did, him meeting the public the way he did. JD won the election for himself. And he didn't say, hey, Nancy, if you campaign for me and I win, they don't have anything like that. That would be a quid pro quo. Her helping him, however, is her First Amendment protected. It's a right protected under the First Amendment. She has every right to campaign for whoever she wants. And of course it wasn't going to be for Dennis Wills. That is not a shock. That is not, you know, it's not a thing. Okay. So January Tomlinson began office. He was contacted May 2021. Godsey, which is her attorney, Mark Godsey, contacted Tomlinson and Burge, proclaiming Smith's innocence and requested a review of the case with the goal that Smith be acknowledged as innocent and formally cleared of all charges in his email. So he's saying, can you take a look at my client's thing? Okay. Case. And see if we can do something here. So a series of emails to Counsel Smith, Lorraine County Prosecutor's Office, detailing a plan to unravel the sentencing agreement. Yeah. And on the sentencing, I want to be very clear here. The sentencing agreement, the original sentencing agreement, on the bottom, it says that she was able to, at a later date, they could, what is it called? I can't think of the word right now. Change pretty much the sentencing agreement of both parties, including the prosecutor's office and her attorneys agreed to. They can change the sentencing agreement. So she was allowed to amend the sentencing agreement. It's not a thing. So there's all these emails between Burge and JD, and because Jim Burge, who was the judge that acquitted originally Nancy Smith and Joseph Allen, was now working as the chief of staff of the prosecutor's office. So Tony Cillo is pretty much saying, hey, since Judge Burge acquitted her, worked on her case, it's inappropriate for him to be working with her attorneys or speaking with her attorneys or having anything to do with this case. I want to be very clear. It is not illegal. There's no law that says Judge Burge couldn't do what he did here. And you'll see that from the judge himself. But he basically says because of these emails, Judge Burge had something to do with, you know, this case. Now, I think it's silly. And that there was Tony Cillo's other argument also is that there was no new evidence that would suggest a new trial would be given if this evidence was revealed, which is also a bunch of nonsense. So we go through here. It's just a bunch of emails between them talking about the judge, talking about the case, talking about how they're going to file, talking about how they have to file. Now here, dear Mr. Burge, per our conversation, you and J. Thompson are privileged to speak to the judge ex parte about my client, Nancy Smith. So this, I want to be sure you guys see, is this right here is saying that the judge knew that they're all talking, okay? They were very well aware, Judge Cook, who was the judge in this case, Lorraine County Common Pleas Court. But there's what Tony Cillo is trying to say is that they conspired. They conspired, talking about their case and what they're going to file and how they're going to file it and everything like that. That's not conspiring. That's just talking about a case. There's nothing wrong with that. There's nothing that says they can't do that. They do it all the time. But, you know, because their research, because of them communicating, Tony Cillo pretty much wants to say, hey, they colluded together to dismiss her charges. I don't really think that's a thing. Now, in the middle of all of this, though, they do talk about how the Attorney General is going to try to fight this on his end. Because if Nancy Smith and Joseph Allen are found innocent and are found or charges dismissed or found being wrongfully convicted, they can then sue the state of Ohio, the county, the city for wrongful incarceration monies that they are entitled to under the law of a state law of Ohio. So they're worried about that. So they are expressing their concerns. Let's see. I want to find affidavits. So they had the new evidence that they had, and this is where we'll go to. Intensive response. So the prosecutor couldn't motion to ask for a resentencing or anything like that. So Nancy's attorneys are the ones to first file to ask for amendment to the sentencing agreement, which, yeah, in order to describe the sentencing agreement, Godson and Burge needed to modify it prior to Godsey's seeking trial, because under the sentence agreement, she wasn't allowed to re-litigate this. Yeah. It forcibly prohibits from engaging in a type of litigation associated with this matter, since she had to receive the benefit of bargain of the state of Ohio's agreement not to require her to serve for the prison time. So she, and Amber talks about this on the her daughter, Amber, talks about this on the Madhouse the Madhouse podcast, how, you know, she was asked to come to the prosecutor's office after hours with her attorney. And basically they told her, if you don't sign this, if you don't agree to the sentencing agreement, you're going to go back to prison. So she ended up agreeing, well, like most people would, to the sentence agreement that was given to her by Tony Cillo, who's the now prosecutor filing this, this judgment asking to vacate the judgment. He was there, and Dennis Wills, then county prosecutor, Dennis Wells, was with her when she signed this 2013 sentencing agreement. Both said also that they didn't want her to go back to jail, that they thought that she had served enough time. They said that during her court hearing, which I find really interesting. So, they're just talking about filing the sentence agreement. All right. So, let's see here. So this is where they changed sentencing agreement. Ultimately, the parties ended up drafting a document that included that Smith would be able to permitted to file a motion for a new trial to challenge her convictions in the case. Smith's pursuit of a motion for a new trial shall not be breached of the sentencing agreement. Should a motion for a new, now this is another thing that he wants them to vacate. Should a motion for a new trial be denied, the sentencing agreement shall continue in full force. So they said if the judge looks at all the evidence, the judge says no motion for a new trial, this original sentencing agreement will stay how it is. Now, should a motion for a new trial be granted, so the judge grants a new trial, the parties shall execute in subsequent writing that they shall terminate and declare void ab initio the sentencing agreement, which means if the judge said, yes, I'll allow a new trial to be granted, then this whole sentencing agreement is nothing, null and void, doesn't even exist anymore. Okay. Now, Tony Cillo points out the document is silent as to any benefit gained by the state of Ohio under these new terms, or any benefit Smith would be given up. The sentencing agreement was amended before the motion, so no violation of the sentencing agreement. Yeah, so the sentencing agreement was amended before the motion for a new trial, hence there was no violation of the sentencing agreement. Now this is what my question is why would she need to file? Now, this isn't his other argument, is that she would need to file is that this sentence, sorry, I'm not trying to confuse you. This sentencing agreement, when it says motion for a new trial, his argument is it says it does not give her permission to file a motion for leave. So since this little thing right here didn't say motion for leave to file a motion for a new trial, he's saying that it wasn't correct. But my question is also, a motion for leave of court is a formal request or a court's permission to take an action that is not allowed as a matter of right or that goes against the standard procedure. So basically, all a motion for leave is to ask a judge. So Tony Cillo is trying to say, like, she wasn't allowed to ask the judge for a motion for a new trial. So, like I said, my question is, why would she need to file this? Is it because of the sentencing agreement amended? Why would they need permission? JD is the prosecutor. So if he wants to ask the judge something, he has every right to ask the judge to look at a new case, or her attorney's every right. I don't think he needs to say. It's semantics he's playing, pretty much. The judge decides the motion for leave. You know what I mean? If he's going to grant it or not. So if it wasn't appropriate based on what Tony Cillo is claiming, then Tony Cillo is claiming that the judge is wrong for approving the motion. That the judge doesn't know what he's doing. Because I will tell you this, Judge Chris Cook was involved with this whole thing as well. So if Tony Cillo wants to say JD is defrauding or some quid pro quo, then he's saying that the judge was complicit too, which is my biggest argument. So Tony Cillo, our current prosecutor, is saying that one of our current judges doesn't know how to do his job. Didn't look at the evidence, just made a decision out of the blue, which is a lie. It's a lie. It's a lie. Like I said, the judge would be part of Cillo's conspiracy if he was meeting with all parties based on the email above. December 14th, Smith filed amendment. Let's see. Ohio filed its response signed by J.D. Thompson, which also generated the group's conspiratorial planning. But if you look at the emails, Judge Chris Cook was a part of those emails. He was in contact and conversation with Jim Burge and JD the entire time that they were working on, not the entire time, but most of the time that they were working on this. On December 22nd, the court held a hearing to consider Smith's motion for leave to move for a new trial. During the hearing, the following exchange took place in the court. Judge Christopher Cook presiding, the judge with whom Burge claimed to have spoken about this matter before it was filed. Now, again, the judge whom Burge claimed to have spoken about this matter before it was filed, and Tomlinson. Well, the judge would have, then if you're saying that Tomlinson and Burge were under some part of conspiracy, you're saying the judges too. The judge would have to be too, because he was involved. If that was a conspiracy that the attorneys were talking to each other and that the attorney gave ex parte, that means that you can talk to the judge without Nancy Smith's attorneys. So that just tells you that they were all talking. It wasn't anything secret. Moving attorney and play kind of prosecutor. So the court, moving on then, I want to read this part. Attorney Tomlinson, you and the employee of Lorraine County Prosecutors is one James Burge. Attorney Burge, formerly Judge Burge, was a judge who had a hand in this case at some point and appears to, in fact, have actually made substantive rulings in this case. Attorney Rosenbaum points out in this motion that a judge under Rule 1.12 shall not represent anyone in connection with a matter in which a lawyer participated personally and substantially as a judge, unless all parties in the proceedings give informed consent. I don't know if there's been informed consent. But he said, now listen what he said. He said, I don't know if there's informed consent, but there might be informed consent. Nancy Smith's attorneys might say, yeah, we absolutely want Jim Burge to work on this case. Then there's no issue. Does it look good? No, but there's no issue then. It's not illegal. It's not against the law. It's not a crime for Judge Burge to work on this case, period. Now, he said, but it's very clear to me that Attorney Burge is to be disqualified from any involvement in this matter, as he was a judge and he should not. And then he stopped. He has not signed any pleadings to my knowledge. He has not appeared in court. Can you assure the court and all parties that Jim Burge, former Judge Burge, in your office will have no role in this matter? Now listen to what Tomlinson says. He's very clear. Tomlinson, the former prosecutor Tomlinson, says, Judge, he is not the counsel of record. I am. And the court, all of the evidence that was reviewed by the state of Ohio and the analysis that took place thereafter was done by myself, 2 investigators, and another assistant prosecuting attorney. Your Honor, Judge Burge was not involved in that particular process. Now, what I found interesting reading the December 22nd, this date, was it December 22nd, this hearing date? Tony Cillo was there. He was there in the court, and I'll show you that. The court, thank you. Now, Burge was not involved in the reinvestigation. Is he involved in the emails back and forth with them? Yeah, but there's nothing wrong with that. The judge knows about that. Burge went to the judge and talked to the judge about this case. So there's also, again, nothing illegal about that. It's not a crime. It's not it's not conspiracy. So just email these to the judge. Burge can't control someone emailing him. You know what I mean? There's no response to this. And he said, Judge Cook attached are the sentencing agreements of Joseph Allen, Nancy Smith. If you need anything else, just let me know. So he's looking at the sentence. So the judge is looking at the sentencing agreements to see if it's appropriate to whatever. So on December 29th, and that would be how many days after this? Day after this, the court granted Smith leave to move for a new trial despite her this is Tony Cillo's claim, despite her not having permission under any circumstance to file the motion in the first place, and also accepted her filing amendment to the sentence agreement attached. The court granted Smith's motion for a new trial, February 25th, 2022. Additionally, that date, the parties executed documents what happened to show. So he's all saying Thompson dismissed the charges and then February, Thompson dismissed the charges. This is now the second conspiracy. So the first conspiracy was Jim Burge working with Nancy Smith's attorneys and the prosecutor. That's not a thing. We already ruled that out. Not a thing. Now, the second conspiracy and the quid pro quo was Nancy Smith winning JD an election, which wasn't a thing. Nancy Smith helped on the campaign. It was her First Amendment protected right to do so. So the second conspiracy, Thompson Burge accomplished their goal of manufacturing this case to resolve the dismissal of all charges against Smith. But they did not stop there. Instead, they collaborated with attorney Michelle Barry Godsey, the spouse of Mark Godsey, and Barry Godsey's filing of a complaint for Smith to be declared wrongfully imprisoned individual in an email Burge dated March 29, 2022. Now, these are my notes. When I put this, court granted, accepted the file for sentencing agreement. So why did I put this? For this, the sentencing agreement was amended. It was amended. It was filed first, which allowed for the motion of a new trial. New amendment sentence agreement stated that if amendment granted a new trial, the agreement would be void. The prosecutor dismissed due to concluded Smith and Allen are innocent based on the investigation discussed previously, new evidence. Okay. And then this part where they Prosecutor Tomlinson will declare them a wrongfully imprisoned person. He said that during the trial. He said, I believe she's innocent. He said that when he dismissed all the charges. So he's saying, despite, Thompson assurances court, Burge became involved in this matter and responded as well. Well, now this is a second matter. So the judge Chris Cook said, Burge is not supposed to, I don't want him involved in this court matter, just where it would be amending the sentencing agreement at court and then dismissing your cases. He wasn't involved in that. He wasn't involved in the investigation. He wasn't involved in any of that, besides being the chief of staff and getting emails back and forth and talking to the judge originally. So none of that was out of purview. Now he's saying that now that this is dismissed, Burge became involved in the matter regarding her complaint to the state of Ohio, I believe, for her wrongfully in prison. Well, this is an entirely different matter. He was not told by the judge not to be involved in that. And then again, as long as Nancy Smith's attorneys give Burge consent, there's nothing wrong here. So the other argument that Tony Cillo has is, he's not thinking of what's good for the state of Ohio. April 1st is filing special 3.8. Now, okay, so Tony Cillo's argument, I just wanted to see what I said in my notes first. Tony Cillo's argument is this: he's the legal representative charged by law to represent the state of Ohio. He specifically has court to rule against the state of Ohio and permit Smith to bring action against the state of Ohio for damages. A prosecutor is not just a prosecutor. Okay, this is where Tony Cillo is wrong. You have special responsibilities as a prosecutor. For example, Model Rule 3.8 reflects that unlike lawyers in a private practice, prosecutors have a duty to seek justice, which courts recognize and prosecutors acknowledge. The Common Company Rule 3.8 explains that a prosecutor has a responsibility of a minister of justice and not by simply that of an advocate. So basically it's saying like he has a duty, if he, under this rule, that he knows that these people are innocent, to bring it back to court. He has a duty under this rule and under being a prosecutor in general to seek justice. Seeking justice is not keeping wrongfully imprisoned people in jail so the state doesn't get sued. That's not a thing. And what I found really interesting about this argument is that, once again, it lines up. Well, I don't think I've said this yet, but I'm going to say this now. The prosecutor Rosenbaum, Assistant Prosecutor Rosenbaum, who was the prosecutor who prosecuted Nancy Smith's original case, had the same argument on December 22nd of 2021 with the judge. You know what the judge said? Are you saying that, a prosecutor shouldn't bring up innocent, if somebody's innocent because the state might be at risk? What about the duty to seek justice? And Rosenbaum then backtracked. But I find it really interesting that Tony's motion here, I don't know if you call it a motion. I gotta see at the top what it says, but filing here says the same thing, that he's not representing the state of Ohio because the state of Ohio might be sued for damages because she was wrongfully incarcerated. And at this time, on April 29th, the Ohio Attorney General's office filed a notice of appearance and counsel on this matter, as well as on the behalf of the state of Ohio, and initially addressed Ms. Averments and asserted affirmative defense. So this occurrence set off a handful of email discussions, and then he's saying that these email discussions about the Attorney General was a civil action conspiring attorneys, which that's not a thing. It's just not a thing. So Michelle Bergazzi emails James Burge. So it appears the AG's office contested Nancy's declaration of innocence. They never served this on me, but this is the answer. The AG's office filed April 29th. I just got it from the clerks. So they even let your office know. So then they decide that they were going to go through and file a motion. My thought is that we filed these joint stipulation motions we originally planned. AG's contentious answer because it would officially place on the record the facts that the state of Ohio admits via the prosecutor that she's innocent. From there, it will probably depend on the judge. If the judge is not willing to grant this due to the AG's office contesting the facts, we'll have to move forward with a motion summary judgment, which is a legal request to a court to rule on a case or parts of it without a full trial. But the judge won't want to continue this charade. The AG's office can't even possibly overcome the stipulated facts in the Lorain County prosecutor's investigation, witnesses, everything like that. So he's saying pretty much like we're going to file a joint stipulations motion because they want to place on the record JD saying the current Lorain County prosecutor saying that what the state of Ohio did was wrong and that Nancy and Joseph Allen are innocent. So then he said the conspiring group, because it's, Nancy's attorneys and his, but they both want the same thing, is Nancy being free finally and also getting her what's due to her for being wrongfully in prison. He's saying that they were conspiring, and Burge had the following email exchange with author Bernard Rosenthal, the real reason for his involvement. Now, so basically Tony Cillo is saying the only reason that James Burge was involved was because they are trying to get her compensated. Not the fact that this guy has been saying since 2019 that Nancy Smith and Joseph Allen are innocent, wrongfully convicted, and that it's wrong. That's just wrong. And it's a stain on our judicial system here in Lorain County. That's what it is. So Smith filed a federal lawsuit as well, seeking civil rights violations. She's named Lorain County and her federal election style currently pending. So law and argument. So these are his arguments. This court's judgment on the amendment to the sentence agreements are fraudulent or void, and therefore the court has inherent power to vacate them. They're not fraud. So again, he's saying that the judge made a mistake and that because these people worked together, that it's fraud. And now because it's fraud, the court should reopen this case, which I don't think is a thing. And then it's just his legal argument. And then the execution, next one, the execution of the amendment to the sentence agreement exceeds the scope of the legal authority of the prosecuting attorney. It is their ultra virus and ultimately void. Again, we're thinking of prosecutors seek justice. So I put that rule there. Now, Tomlinson, the court had never had jurisdiction over the actions taken by Tomlinson because they were beyond his scope of statutory authority to act. Well, Tomlinson, for one, wasn't the first one to act. Nancy's attorneys were the first ones to act to ask for the resentencing. Tomlinson then had every right to do so. Now, also, I want to bring this up. The state itself was created to protect individual rights, not to protect itself and its electors from whatever they did or people working underneath the color of law. Tomlinson, as a prosecutor, had every right to amend the sentencing agreement that was requested of him to do so. Now, he didn't have the right to reopen this himself, but her attorneys filed the motions to amend the sentencing agreement and then also to move for a new trial. Now, he says the Office of the County Prosecuting Attorney is a creature of statute, and that he almost should act on, behalf of the state. And he says this again: the prosecutor shall prosecute on behalf of the state all complaints, suits, controversies. Well, he is. Part of being the state is to protect civil rights, protect Nancy's rights, and that's what he did. She was wrongfully convicted. Let's see. New evidence. So her sent to hear the sentencing agreement was intended without dispute to completely terminate all further proceedings in this matter. So he's saying that, we had a sentencing agreement, yeah, but it was supposed to end all of this. And in fact, the terms were fulfilled upon the courts having accepted and issuing the Smith's correspondence. There was nothing left to be done. The case was over. We were finished acting in accordance with the sentencing agreement. Well, that's not true, because on Nancy Smith's sentencing agreement, it said it could be amended. And that's what they put in for her attorneys, is to amend the sentencing agreement to allow her to prosecute. And that's what they did. But he's still offering no benefit to the state. Then he's saying that the sentencing agreement that Prosecutor Thompson didn't benefit the state, only benefited Nancy. But Nancy was a resident of this county. The state was created to protect the residents' rights, the citizens' rights. So how is he not acting on behalf of the state when there's an injustice? I don't understand that. And it really tells you how our prosecutor thinks. Our prosecutor thinks like, damn you being, wrongfully incarcerated, innocent of the charges. If you could be a liability to the state of Ohio and, go after them for compensatory damages, then I'm going to keep you in prison. That's what our new prosecutor thinks, Tony Cillo. That's, Now, this statement kind of freaked me out. Are they thinking of charging Smith again, is what I wrote, because it said, on the contrary, the amended sentence agreement allowed Smith to be burdened the state with the prospect of a new criminal trial, despite this matter having been closed and settled for years, and despite the parties having intentionally executed a sentence agreement to end all litigation. And why would you say that unless you're thinking of retrying her? And that would be this woman's, I think fourth or fifth, like not trial, but like sentencing. And this would be, and I think she'd be found innocent immediately just because of the new exculpatory evidence that would come out. I think she would be completely innocent because her attorney, Bradley, for some reason, was the worst attorney on earth for her. And she'd actually get proper representation. But this is crazy. Now, he said it's also an issue because he didn't discuss, Thompson didn't discuss with the commissioners about the actions taken in Smith's re-amendment to her sentencing agreement and new trial. He didn't have to. He was prosecuting attorney. He wasn't bringing in a special prosecutor like some people do without asking the commissioners, even though 305.14 states that you need the commissioner's permission, Tony. Looking at you for your Ottawa County investigator. Did I say that? But, he's a prosecutor. He can do what he wants. It's his office. He's an elected official. He had every right to do what he did. And no offense, that's another question. If Tomlinson was out of his authority to do so, he's pretty much saying Chris Cook made a mistake. Judge Cook, who allowed all of this, made a mistake. I don't really think that's a thing. Granting of leave for Smith to move for a new trial was not contemplated with the amendment to the sentence agreement. Therefore, the court, without subject matter jurisdiction, to consider it. It's not true. On the sentencing agreement, leave court permission is obtained from the court to take some action, which without such permission would not be allowed, like amending the sentencing agreement. The argument is dumb. He's trying to say by being amended, it didn't say that she has to ask for permission to amend the motion. What the judge did was wrong. It's a weak argument. So he's basically saying, because she didn't say to apply for leave, so to ask the judge for permission, because she didn't say those two words, the whole thing should just be squashed. And that's semantics. You're playing semantics at this point. She was only given the authority to move for a new trial, not apply for leave to move for a new trial. Well, the judge approved it. So is Tony Cillo saying, the Purdue prosecutor, is he saying that the judge messed up? That the sentencing agreement being amended was the judge not knowing what the heck he was doing? Again, semantics. He's playing semantics. There's no argument here. So finally declaring the sentence agreement void ab initio is caused what Lorraine County would become defendant in Smith's federal lawsuit. Well, this court must exercise the inherent authority to vacate the judgment issued and all judgments issued by this court thereafter. So is basically saying, who cares if she's innocent? He's just worried about the state of Ohio being liable for damages. He's okay with the wrongful conviction, and that is scary. That alone is scary. That Tony Cillo, our county prosecutor, is okay with wrongfully convicted being in prison, because as long as the state of Ohio is not going to be sued. The state of Ohio, which was created to protect citizens' rights. Where he, as a prosecutor, has an obligation, knowing if somebody's going to protect them. He's not doing it. He's not doing it with the Ohio 4. I mean, we've talked about that before. The 2 men are still incarcerated, innocent, clearly innocent, based on the evidence, and Tony just dismissed it. So 3, the amendment to the sentence agreement was executed under circumstances that constitute fraud on the court. Especially it turns out Smith's court filings were not born solely from their own initiative, that of her counsel or that of her counsel. Yes, they were. Her counsel reached out to the prosecutors in May. Her counsel initiated the motion to amend the sentencing agreement. Her counsel did that, not the prosecutor. He agreed to it, but he agreed to move forward with that, but they didn't, because they needed both to agree, the prosecutor and her lawyers. But yeah, nothing. Newly discovered evidence set forth. Filings are born from conspiracy. The newly discovered evidence set forth in this brief reveals that Smith spent time working on Thompson's campaign. Yeah, that's not a thing. That's her. She's protected in her First Amendment to do so. To be an elected prosecutor in return, Thompson actively conspired with Burge and Smith's attorney to engineer a case. It's not a thing. Her working on that campaign was not the reason JD brought this up. And he said that during his campaign. He said, I believe that there's something wrong here. If I get in office, I'll look into it. Now, after doing his investigation with his investigators and his assistant prosecutor, he decided that she was innocent. And he did the right thing. And he said he's choosing to further his own interests. That's not a thing again. He's saying Burge was disqualified from participation in the matter. Yeah, Burge was disqualified from having any participation in court. And regardless of what the judge said, as long as Nancy Smith's attorney said it was okay for Judge Burge to be involved, it's not, again, not a thing, Tony. Not a thing. So you the answer. Their deceit was insidious. Oh, so their deceit was insidious. They made it appear to the public that Smith was taking on the mighty adversary of the state of Ohio, and against all odds, she managed to prevail. She did. And she is. And she's been doing it for over a decade. Even worse, Burge and Thompson's deception seeped into Lorain County courtroom. Because, the judge doesn't know what he's doing, Let's see. Was contravention to the position taken by the Attorney General. Of course it was, because the Attorney General doesn't care about keeping innocent people in jail who represents the state in Ohio in wrongful imprisonment suits. Yeah. Okay. Yeah. It was. Who cares what Dave Yost thinks? Like, to be honest with you, Dave Yost, who protects, HB6 stuff for First Energy scamming us, but wrongfully convicted. You better stay in prison. That's a thing. He's not looking out for you. So he's saying that all these violations, Thompson and Burge engaged in criminal conduct of RC 29.12A2, 29.21.2A. Okay, and 2921.42. So 2921.42 is unlawful interest in the public to contract. This one right here, 2921.21A, is no person shall knowingly demand, accept, or agree to accept anything of value in consideration of abandoning or agreeing to abandon a pending criminal prosecution. He didn't. He wasn't like, Nancy, if you work a little bit on the campaign for me, I'll make you free. That wasn't a thing. Not a thing. make present or use any record, document, or thing knowing it to be false with the purpose to mislead a public official who may or may be engaged in such a thing. Now, this is their argument. This was Rosenbaum's argument again. Rosenbaum's coming up in this because I think Tony Cillo and Rosenbaum worked on this together, to be quite honest with you, because it's the same. And I'll show you why. I'll show you why I think that. And that's my theory. It's not truth. It's not fact. It's my theory. Because he's saying he's misleading. Because Rosenbaum in December 21 of 22 during the court time tried to make the argument that this was signed off by a judge on the sentencing agreement, and it wasn't. It was a resentencing agreement. It was just signed by the parties involved. If it were to be signed by a judge, then the court wouldn't be able to do what they did, but it wasn't. And Judge Chris Cook brings this up during his whole hearing. The Judgements agreement was executed for agreement over which the court does not have jurisdiction. He did again. I just said this. Chris Cook went over this. He had jurisdiction. And the state earlier amended to the sentence agreement was born out of corruption on part of Thomas and Burge, constituting a fraud upon the court and the public. Not a thing. There is no fraud here. I mean, they didn't conspire. There was no fraud. There was, it's not a thing. It's not a thing. There was new evidence which allowed them to bring this in for a new trial. The sentence agreement lacks consideration, therefore cannot abandon and all alter, other modify the sentencing agreement. The sentencing agreement itself said it was allowed to modify the sentencing agreement. Let's see. Simply put, amendment to sentencing agreement. Yeah. So amending it, so basically saying amending the sentencing agreement allowed them to sue. Violates public policy, contrary to the consideration of legal, contrary to public and moral avoid, charge of learning, prosecutor, protecting public funds. Again, doesn't matter if you're innocent. Charges the Lorain County Prosecutor's Office with the duty to protect public funds. The money is what matters. She's going to be able to sue. She might get a lot of money because of how many years she was in prison. That's what we should protect. We should protect the state of Ohio from not being sued for wrongfully convicting this woman and man. Not that, the conviction itself was wrong, but let's keep innocent people. That's what our county prosecutor thinks, people. This is scary. Let's keep innocent people in jail, in prison, because the state of Ohio might get sued. And their what do you call it? Their job is just to protect the state, not your civil rights, not, for justice and make sure justice prevails, not to protect the citizens that elected them. But, if you're wrongfully convicted and you might get paid from the state of Ohio, we better keep you in prison. That is what he is saying. That is exactly what he's saying. Clear, convincing proof. Motion for a new trial. This is all just nonsense. Now, this is where I want to get to. So he is saying that the judge, read these there was new evidence, right? Okay, so the first piece of new evidence was Margie Grondin, the mother that accused Nancy Smith and Joseph Allen of molesting her daughter, wound up years later. Okay, in I believe it was 2022, 21 or 22. She ended up trying to do the same thing to her son. She got caught. So there was a bunch of new evidence. We'll start there, okay? And we're gonna go down the list, and I'll show you why this is relevant. 1, affidavits from Dino Grondin, which was senior, which was Margie Grondin's ex-husband, and Dino Grondin Jr. That was first piece of evidence. Affidavit from the former detective Tom Cantu, the first detective that you saw in that video at the beginning of this episode, who said multiple times he believed she was innocent. Affidavits from Dr. Virginia Braden and Dino Grondin. A report from Dr. Maggie Bruck, and 5 writings from Lorain County Prosecutor Tony Smith's innocent. Now, he goes through all these, but what I'm going to do is I'm going to bring up the the judges who allowed the sentencing agreement, who allowed the sentencing agreement to be amended, who allowed the motion for the new trial, what he says, Tony in this motion, I don't know what the term of this is, his filing, he said that the judge he doesn't believe the evidence would move a jury to proclaim Nancy Smith and them innocent. And I'll show you real quick before I go to the next part. False claims. Hold on, I gotta get to this part. This is what he did, because I broke down what these definitions mean. Come on, what did I do with it? No, he did. I will say this. The judge removed. Okay, so he's saying that the C is entitled to relief from judgment. Come on, what did I do with this? I know Come on, I broke down what the definitions mean. Hold on. It's gonna drive me crazy. Okay. So he says to all of these people, the evidence is clearly cumulative, contradictory, and impeachment evidence. So he's saying it was already established. Clearly cumulative means it's already been established by a previous court. Okay. Contradictory directly opposes the claim theory of belief, and the witness is not truthful. Okay. That's Tony's arguments to all of these, right? He's also kind of claiming that the judge didn't look at all the new evidence and didn't, factor that into his decision to grant a new trial, which is complete bullshit because he did. And I want to bring that up. And where is it? Which part was that? I can't think. Was it part 2? Maybe part 2. I want to see where the judge laid out it all. He said, yes, there's. So Tony Cillo said he didn't work. So while I'm finding this, I'm going to explain. Dino Grandin, the son of Margie Grandin, the woman who first accused, who was the first one, who then got all the parents together and everything. He had a daughter. The daughter, the mom started making claims against his wife for abusing his daughter. His daughter, sexually abusing their daughter. The mother, Margie Grandin, ended up getting custody of the daughter. Come on, where are you? Ended up getting custody of the daughter. It's towards the end. I'm going to make all these documents available. Here we go. Documents available. So the mom is getting custody of the daughter, and the mom ends up not once, not twice, not 3, not 4, not 5 times taking the daughter into the hospital to get checked for being sexually assaulted. Well, one of the times she was visiting her mother at the children's services little center or whatever, and said at the center her mom abused her. And when the sheriff's office got involved, this is in 2021, when the sheriff's office got involved, they found out those claims to be untrue. And it set up, this information was given to Nancy Smith's attorneys, and it set up a pattern. You know what I mean? It proved a pattern that Margie Grandin had of trying to solicit money out of false sexual abuse claims. And her son also said, come on, where did you do with this? So here's Rosenbaum's argument. I need to stay here, but I want to see what the judge. All right. Nope, it's part 3. Hold on. Okay, we need this because this is where Rosenbaum, this is why it's important. Rosenbaum and Cillo are friends. Rosenbaum and Cillo worked together for almost I want to say 20 years. So here, name is Tony Cillo, rule 1.12, but that's not what I want to get to right now. I want to stay on Dino Grandin. So part 3. So like I said, Tony Cillo, so this new evidence came out. Now, Dino Grandin, the son of Nancy Smith, also said during this time that part 3, where are you? Oh, here we go. Also said that his mother coached all of the kids and their parents at the time of Nancy Smith's case. Here we go. So Chris Cook, so since Tony Cillo said Chris Cook our judge did not look at, our common pleas judge did not look at the evidence of everything that happened. Chris Cook actually wrote out at the time everything he looked at. Okay. So we're going to look at it real quick. And I'm going to go through this, but I will post these documents so you guys can go through them yourself. I also have all the documentation from her clemency, which shows, the tests, the statements from people who were never called for trial by Nancy Smith's attorney, Jack Bradley, for whatever reason. So affidavits of the Grondins. Okay. They supported new evidence. Okay. This is the new evidence. This is from Judge Cook. This is Judge Cook's writings. This is what he said. Grondin Sr., which is Dino Jr.'s dad, he says they have children together. They have frequent interaction with Margie and the children, and that he witnessed Margie coaching their daughter on what to say in order to make the allegations of sexual abuse in the Head Start case. Margie would then try to get her daughter to repeat what Margie was saying and agree to the story that she was telling. The senior goes on further to say that persistent in trying to get her daughter to agree with what Margie said happened, that Margie wanted her daughter to practice. She was going to get paid after this case was over. Finally, Grondin Sr. says he recently warned his son, Dino Jr., to be careful because Margie was making new unrelated allegations that his wife, Emily Grondin, was abusing their daughter in order to sue for some more money. Margie, his mother, and that she recently made false allegations of sexual abuse against his wife. Made up all sorts of lies, tried to get the charges brought so she could take custody of the daughter. The detectives who investigated Margie's claims that Margie had coached their daughter to make false allegations, and this is recent. He also states that she told my sister what to say and practiced with her, telling her that she got it right. We would get enough money to go to Disney World at the time in 93 when they made the claims. He said us kids were abused by Margie and a male companion in ways similar to the abuse that was alleged in the Head Start case, which recently resulted from him being hospitalized for a panic attack. Male companion put on black hunter's paint or black dark face paint and some sort of, and pretend to be Joseph to get my sister ready for allegations. So, how she said that the daughter said that Joseph had white spots. That's where he's saying that came from. It was another male companion of Margie's. In addition, Avery's Margie had a picture of a black man on the wall and said it may have been Alan's mugshot. And my sister had to study it to the point where she said it was Joseph. That Margie on occasions had the other kids from Head Start case down in the basement and coached them the same way. Margie played school in the basement with the kids, and that Margie was the teacher, and that they had to say the allegations of sexual abuse the way she wanted in order for them to advance in the game. So he continues claiming that the Head Start case, who are now adults, admitted to him that nothing happened and the allegations were made up. But they were told by Margie, if ever discovered, they would publicly be disgraced and shamed and would have to give all of the money back. That he swears he has no doubt that my mom coached his daughter now recently to say that his wife sexually abused her because she thought this would allow her to sue the state or county. So after the scheme fell apart because she was caught coaching my daughter, the mother, Margie Grondin, lost custody, and custody was of his daughter. Now we go back to the video. So that's just one piece of evidence, right? And this is the judge writing what he sees as evidence. Now there was Tom Cantu. Tom Cantu was never called on behalf of the defense, Jack Bradley, to defend Nancy Smith and say that she passed a polygraph. The jury never heard that she passed a polygraph. That when he first investigated, and he was the first investigator on this, that the children couldn't, said nothing happened, said no when he asked them what happened. That he was transferred, and after he was transferred to a different job, new investigators came in, but those investigators never spoke to him. Cantu believes that he concluded that the children had been coached for financial gain. Cantu had some knowledge or familiar with Smith, but he made sure, because they like to say when you're defending somebody that they're sleeping together. He said he wasn't a girlfriend of his. But one of the parents, he also said that, the children had been coached pretty much. And this case was very unusual. It was very unusual that they didn't call him for his testimony. It was very unusual that the new detectives didn't talk to him. Like it said in the video that I played for you at the beginning of this episode, that, he has never seen anything like it. He got into it with the mayor because Margie Grandin was going all over Lorraine and saying, this is happening to our kids and, getting more parents. So it was crazy. Now, Virginia Braden, she was a private investigator. Yeah, private investigator, behavioral analyst. She goes through what she found. Now, this is regarding to Dino Grandin's daughter. How many times she took her to the hospital to get checked out for sex abuse, which I think is abuse in itself. I just marked it here 1, 2, 3, 4, 5 times she was looked at with finding no claims of abuse. Okay, and even Lorraine County Sheriff's Office determined no abuse occurred when supervised visit and supervised at all times. She left her alone. She practiced pretend crying. The daughter made no disclosure of abuse. Concluded that the daughter had been coached by Margie Grandin, her grandmother, that there was no evidence of abuse, no disclosure of harm, no witnesses to the abuse. Allegations were unsubstantiated and founded, and that during the court hearing, detectives testified that it was evident to him that Margie had coached the granddaughter into making false allegations, which sets up a pattern of what Nancy Smith has done not Nancy Smith, that Margie Grandin has done to Nancy Smith and Joseph Allen. There's also a psychologist that gave a recount of her after she studied the kids' interviews and stuff and the techniques that were used. She basically said it was completely inappropriate. That these kids said, yeah, they were abused and said they weren't, and then just, denied ever being abused. And you guys can go through that. I just want to show you, the Judge Cook did go through these. Dr. Brooks' final conclusion was in her expert opinion. Keith Exon's case are incontrovertible. The children denied abuse in early interviews. When they did make allegations, these were preceded by extremely suggestive interview techniques that rendered all subsequent statements unreliable. And then these are all the affidavits that they received for Nancy Smith. So she says, I want to go down here. Q2's affidavit, Braden's affidavit. Now, this is what Judge Chris Cook, who allowed the amendment to the sentence agreement, then allowed the new motion for a trial, says. The next inquiry then is whether the content and substance of what is alleged in the affidavits and reports was available to Smith and Allen with due diligence at the time of the trial. The court finds it wasn't. So he also finds, which is really important right here, if admitted at a new trial, will the evidence result in a different verdict? Okay, that's one of the biggest questions. And then this is what he states. Judge Chris Cook, which, Tony Cillo claims that, the judge didn't even read the affidavits and doesn't understand, the evidence. The new evidence disclosed a strong probability that will change the result in a new trial is granted. Is material to the issues, is not merely cumulative, and does not merely impeach or contradict the former evidence. So what did Tony say? It was cumulative, it was contradictory. So the judge that allowed all this to happen is saying it's not. The new evidence submitted in support of the motion for a trial is compelling. The Grandin affidavits present a pattern of sinister manipulations orchestrated by Margie to manufacture allegations of sexual abuse by multiple children, by successfully convict Smith and or Allen in a new trial. And then he talks about, the affidavits, Cantu, all this stuff, and he goes all through it. Now, today's determinations do not render yesterday's decision unethical. On this point, the court makes one additional observation. This is what he says. This court does not find, and has been presented no evidence that indicates that former prosecutors Prosecutor Gregory White, Jonathan Rosenbaum, Dennis Willard, Tony Cillo, or any members of law enforcement that were involved in the initial investigation and prosecution of this case acted malice or vendetta. In fact, prosecutors Will and Cillo entered into sentencing agreements with Smith and Allen that substantially reduced their sentences. And to be fair to Prosecutor Thompson and those who agree with him on the issue, the court did not investigate the matter anywhere near detail that he did, nor did his court review discovery, trial transcripts, or motion rulings. While this court has great respect for all the prosecutors that have been involved in this case from the beginning to present, I believe that it is difficult or perhaps unfair to judge the actions of individuals that occurred 29 years ago through a present-day lens. In 1993, the law was different. Children interview techniques were in their infancy, and the nation was gripped by a virtual hysteria regarding lurid, rampant allegations of sex abuse. Now, this is very important. What Prosecutor Thompson has done in reviewing the Head Start case is appropriate in his role as the Lorain County prosecutor, and he should be commended for fulfilling his commitment to the public to do so. But his findings, valid through they may be, do not compel the conclusion that those who came before him were unscrupulous. So he's just basically saying, I don't have any evidence that they did something wrong, right? I have questions. The granting of a new trial, even if the charges are ultimately dismissed, is not tantamount to exoneration. So even though she's getting a new trial, she's still not exonerated, people, okay? She's not. But in short, the court does make declare judgment as to Smith or Allen's innocence. Not saying if they're innocent, but they say that they're entitled to a new trial. The Ohio Attorney General, an independent prosecutor, will evaluate an appropriate defend the state of Ohio and any wrongful imprisonment actions filed by Smith or Allen. So, that being said, it's pretty self-explanatory. Court dispenses with his argument as he duly elected Lorain County prosecutor. Prosecutor Thompson is well within his discretion to prosecute or refuse to prosecute cases he sees fit, including this one. That said, it should be noted that in the event either Smith or Allen or both file a wrongful imprisonment action against the state of Ohio, will be defended by an independent prosecutor, the Ohio Attorney General. That office represents the state in such actions. So he's saying, even though he's, letting this new trial, if they file for a suit, it would go through the Attorney General's office. So it is hard to imagine surrounding investigation, prosecutions, and convictions of Smith and Allen, coupled with the community's continued concern, apprehension about the case, failed to play some role in Prosecutor Will and Cillo's decision in 2013 to revisit these cases and offer significant accommodations to both Smith and Allen. Similarly, Prosecutor Tomlinson picked up the ball and fulfilled a campaign promise to the community to take a fresh look at the Head Start case and reviewed the matter from a new, different, and comprehensive perspective. Request for a new trial, and he has taken the matter one step further by affirmatively proclaiming their innocence. While granting a new trial is justified under existing case law, there is separate reason for a new trial. The alleged manipulation of the criminal justice system by Margie for the sole purpose of financial gain violates our basic concepts of fundamental fairness and due process of law. Ohio Criminal Rule 33, the rule provides for new trials. Is there any reason that a citizen should be convicted and imprisoned for a crime they may have never occurred, cannot be allowed to stand without the opportunity for a new trial? The integrity of our judicial system demands nothing less. This court finds by a significant margin that the new evidence is substantial, credible, and without reasonable doubt. The outcome of such a new trial, that it would be difficult, if not impossible, to secure a new conviction of either Smith or Allen at a new trial. But as for today, the law, justice, and due process mandate that they are entitled to a new trial. So Tony Cillo is saying that the court was defrauded, that they didn't know about, they weren't aware of all these things Judge Cook was involved in. Judge Cook says right now he's reviewed the new evidence and found it, substantial to the point of granting a new trial. Tony's saying in his brief that he did not. And so really, if there's some kind of conspiracy, you would think the judge would know. You know what I mean? The judge wouldn't be wrong. But Tony Cillo, our county prosecutor, is saying that one of our county common pleas judge, Chris Cook, one of the, which I would say one of the better, one of the good ones that we have, is wrong in his ruling, and should disregard his ruling and reopen this wound, because, and honestly, what I believe, his friend Jonathan Rosenbaum is upset about it. That's what I believe. I believe that because the arguments that Tony Cillo uses, are invalid. And the arguments have already been used previously with Jonathan Rosenbaum, who was the original prosecutor of this case, who left out exculpatory evidence, who pretty much railroaded Nancy Smith and Joseph Allen. And Tony Cillo, was a part of that as well, because he's the one who did the sentencing agreement, So he's probably a little upset too that his sentencing agreement was a little upset. Rosenbaum had no issue with, Chris Cook taking on this case. He brought up one of the same arguments as Tony Cillo, Rule 0.12 should not represent anybody. Like we went over earlier, that's not a thing. Attorney Burge is used to disqualify any involvement in this matter. Sentencing agreement, Burge not. All right, that's one of the arguments. Let's go for a different one. And Rosenbaum argues the same thing Tony Cillo does. We're down. And I will say with Chris Cook, if you go through this affidavit that I'm going to put up, Chris Cook says, like, hey, you're suggesting the state always support a former conviction, or the state always must take the position of victims, even if the state believes that the evidence has changed. That's one of Rosenbaum's arguments. Again, same argument as Tony Cillo, is that he shouldn't, bring this. And Chris Cook brings up that, we've seen a lot of cases come up in this that, wrongfully acquitted people, are exonerated all the time. And especially lately, And Rosenbaum says, certainly, I think I made a substantial preliminary showing. It was new evidences, certainly subject to some huge doubt. So Burge says he doesn't believe the new evidence. He doesn't believe, grounded in them. And he says, JD is just picking up where Jim Burge left off, where he wrongfully acquitted these people, don't review the evidence, which is the acquittal was his trial. Like Jonathan Rosenbaum was the prosecutor here. And then Jonathan Rosenbaum comes in, and the reason he's involved in this right here is because Jonathan Rosenbaum comes in as a attorney for the two of the victims, which they'll bring up later was inappropriate. He's not allowed to represent them because he was the prosecutor on their case. So we've undone what Dennis Will did for whatever reason. He's upset that was done. Court just Judge Burge personal sentiments. Hamilton said campaign. He was going to look at this again. Campaign of his mentor. So then here you go. Jonathan Rosenbaum, not Tony Cillo, but Jonathan Rosenbaum, Tony Cillo's friend, brings up again that, there's a mandate. Judge Burge actually the case reprehensibly displayed a direct mandate from the House Supreme Court. He never, he has an issue with Judge Burge being on this case, bringing this back up. He's saying that's why JD's doing it, for him. And this is what I like about Judge Cook. He said Prosecutor Thompson won an election against the sitting prosecutor, and couldn't this court or the community also look at it from the lens that the community wanted this case to be reevaluated? Yeah, the community wanted this case to be reevaluated. It wasn't just Tomlinson. And Rosenbaum said Thompson's preventing that from happening. He's conceded the entire issue, and I don't believe he's done so in good faith. But he can't give an example. But Chris Cook says, all right, well, let me ask you two questions, right? He said, why is this an issue that Tomlinson's doing this? Individuals go through multiple appeal situations, could upheld affirmed results. So why is that the fact in of itself just positive here? So why is it an issue that they want to settle this pretty much? And Rosenbaum says the evidence they're claiming is new now or couldn't have been used before is not the case. all the same arguments that they've all been raised. So basically, Rosenbaum's bringing up the same argument Tony Cillo is, and which I find really interesting that in December of 2021, Rosenbaum is bringing up the same old former assistant prosecutor Rosenbaum, who prosecuted Nancy Smith and Joseph Allen, is bringing up the same arguments that Tony Cillo is in his motion now. Do you think that's a coincidence? Now, Thomason says during his court, I take issue that you're bringing James Burge as directing these actions. He says, and JD is very clear, I am the Lorraine County prosecutor. My name appears on these motions. Those decisions were made exclusively by me for the record. So he puts on record that he's the one making these decisions. He then also points out, Mr. Parsons, one of the attorneys, Rule 1.11a, that Rosenbaum shouldn't even be there because otherwise expressed agreement by a lawyer has formally served as public office or employee of the government. He shall not otherwise represent a client in connection with the matter in which the lawyer participated personally and substantially as a public officer or employee unless appropriate by the government agency informed consent, confirmed in writing to the representation. So he's like, Rosenbaum shouldn't even be here. Why is he here? He can't represent those people. It's against this rule. And then, he concurs, whatever. So, recantation, recitation of new evidence. So then Mr. Gotti, his attorney, says what he's saying about the evidence is not true. He's misstating quite a few things. Not going to get into it, but Rosenbaum, doesn't have an argument here. So, and again, the court says, why can't two consenting parties contract in or modify their agreement? Right? Why can't they? Sorry, I have to exit out of this because it's slowing my stuff down. Oh, no. Why can't they get an agreement? And Rosenbaum will say it wasn't an agreement. The judge signed off. Sorry, hold on. The judge signed off on it, and the judge didn't. It was a sentencing agreement. It wasn't a Rosenbaum. It's more than an agreement, Your Honor. It's a judge. It's the final judgment of a court that was the Judge Sinclair put on that. And again, there should be a hearing as to why this even occurred in the first place. There should be some sanctity in the judgment. And you never understood why Nancy Smith got to get out of jail and Joseph Allen didn't. But I think the whole deal should be inquired of in court because obviously this court believes that Dennis Wills, for looking at this case, was a result of the fact that he questioned the validity of the conviction. So that implies to me that the core contract, that there was a contractual agreement, not a final judgment. And then he goes to JD, says, are you lying to me? That was this signed by a judge? Is this a final judgment? And then they figure out that no, it's not a final judgment. They had every right to go into the contract. It wasn't a final judgment. Judge McCow, Judge Sinclair never signed the agreement. It was just a resentencing hearing, a resentencing agreement. Again, he says, what happened in 2013 is not for me. And then Rosenbaum again says, but it was my understanding that Judge Sinclair did somewhere at some point sign off on this. Now, maybe I'm wrong. He's wrong because you can go down later and see that it was wrong. But my whole point of showing you this was, Tony Cillo is accusing Prosecutor Tomlinson of defrauding the courts, of committing fraud. And I want to be very clear to you guys that I think the only two people that were conspiring in this case was Tony Cillo, Prosecutor Tony Cillo now, and Jonathan Rosenbaum, who prosecuted Nancy Smith. His arguments itself are invalid. They just don't make any sense. How do I want to put this? He is trying, it's like retaliation. He's trying to harass And honestly, I think this is more harassment on the case of the prosecutor to Nancy Smith and Joseph Allen. Leave him alone. And the only reason he's upset is because they're going to sue the state. At no time did Tony Cillo say, these people are innocent. I want to retry them and get it on the record. No, he's doing this for his friend, Jonathan Rosenbaum, who prosecuted these people, who looks horrible for prosecuting these people. And I think if you think of conspiracy and not working on behalf of the public and working on behalf of yourselves and politicizing and weaponizing our offices, it would be Tony Cillo, not the former prosecutor, J.D. Thompson. Nancy Smith and Joseph Allen deserved a new trial. Their charges deserve to be dismissed. They don't deserve to be, drudged up again and ran through the ringer again by a prosecutor who just wants to make sure that they don't sue the state. Innocence isn't even a factor with Tony Cillo right now. He doesn't even talk about the victims, Tony Cillo. He doesn't talk about the new evidence. He just says, why did JD do this? JD shouldn't have done it. He was just upset that JD and Burge did it. But my biggest argument too is that, if they're saying that JD and Burge did something wrong, they're saying the judge did something wrong. The judge, Chris Cook, acted out of his authority, out of his scope, out of his range. And I don't think that's true. I think Judge Chris Cook, did what was right. He had new evidence and he looked at it. But the fact that he says in his motion, Tony Cillo, that, the judge didn't appropriately look at the evidence. What? He wrote a 10-page thing that we went over looking at the evidence, new evidence. The new evidence would clearly show that, Nancy Smith and Joseph Allen would be found innocent and exonerated. And they should be exonerated after everything that they went through. And shame on Tony Cillo for bringing this back up. And I hope to God he drops it because it's just ridiculous. And they're not going to win. I'll tell you that right now. I mean, I highly doubt they get to overturn this. But, I've been surprised by less, to be honest with you. But I think the conspiring here, and I'm going to say it again, the conspiring that took place here was between Tony Cillo and Rosenbaum. And honestly, I think it's really funny that their arguments are the same in the court case in 2021 and Tony Cillo's motion now to vacate the judgments are the same. And I just bet there's communications about that. But we'll see where that goes. So stay focused, Lorraine County. Don't allow the nonsense to bog you down. And I'm going to leave you with this video on why, again, I think the two conspiring actors here were Tony Cillo and Jonathan Rosenbaum, because this is where Jonathan Rosenbaum left it off with Nancy Smith and Joseph Allen. And have a good night, and thank you for tuning in. And I will see you guys all soon. Hold on. Have a good night, you guys, and stay focused.
Prosecutor Jonathan Rosenbaum, who says the original trial was fair, the verdicts and the convictions upheld on appeal. In an email to Dateline, he said, "The real question that should be asked in this case is why are the most heinous sex offenders that this county has ever seen still at large after the Ohio Supreme Court has ordered their return to prison?" In the end, perhaps the only thing that both sides can agree on tonight is that in this case, the system failed. Either guilty people are free or innocent people have been wrongfully denied their freedom.
Am I ashamed of the system? Yes, because I'm a part of it. And the way our rules work, this isn't supposed to happen. We can't repay Mrs. Smith and Mr. Allen for what we've taken from them.
For Nancy Smith, every day spent outside of prison is priceless. Too priceless to waste wondering about the life that might have been.
and they deserve not to wonder anymore. Have a good night, and thank you for joining me. Thank you for joining me today on Mean Street. I hope you enjoyed the show. I would greatly appreciate it if you would consider supporting our work and supporting my effort. You can support directly underneath at the Spotify donations, or you can directly give a donation at paypal.me/Mean Street, Ohio. Any donation received will help me continue to provide news to you and everyone else across Ohio and beyond. I love what I do, and I just hope to continue to do it. Thank you so much, and you have a wonderful day.